Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. All right, let's talk about your case management system. Maybe you're still drowning in spreadsheets or stuck with software that feels like it's from 2015. No offense, 2015. The podcast friends at e-Immigration recently published an ultimate immigration software buyer's guide. I wish I'd had it when I was shopping for our firm's case management system. It's got real comparisons of the features that actually move the needle. Head to get.eimmigration.com/resources to grab your copy and pick like a pro. Or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. So much to talk about, as is the case every week. And that's not including the 8 decisions we're about to get to, which are some big deal decisions. First, some of the bad. Actor-director Owens in PM 25-42 states, quote, adjudicatory outliers or statistically improbable outcome metrics, particularly relative to EOR's overall adjudicator core, may be indicative of a systemic bias or failure to adhere to applicable law and warrants close examination and potential action, end quote. In other words, it looks like EOIR is going to go after immigration judges whose decisions it does not like. And that is not how a court is supposed to operate. Also this week, the Fourth Circuit slightly amended its Alvarez-Ronquillo aggravated felony firearms decision from episode 277. But the big news this week, on Friday, the Ninth Circuit affirmed a district court order granting preliminary relief in the form of a postponement of the effective dates of actions by the DHS Secretary to terminate TPS for Venezuela. Importantly, the Ninth Circuit held that the ACLU and the plaintiffs were likely to succeed on the merits of their claim that, quote, the vacatur of a prior extension of TPS is not permitted by the governing statutory framework, end quote. That's big news, and it affects hundreds of thousands of Venezuelans. And it's similar to our own recent win with Brian Cave and many others in the Eastern District of New York for Haiti TPS and the HECA lawsuit. Similar but not the same. That team, that is the HECA team, is now fighting again for Haiti TPS holders on the final February termination in the District of Columbia, and that lawsuit is picking up steam. Great work by the ACLU and the Ninth Circuit. The TPS will surely be at the Supreme Court's shadow docket again soon. And also stay tuned for whatever passive-aggressive statement U.S.C. is sure to make on the TPS website about this Ninth Circuit order for Venezuela TPS. It is getting a bit entertaining. Alright, enough about that. 8 cases this week. Lots of learning to be done. Lots of learning to be had. Lots of learning. Starting now. Our first case this week, if you know, you know, is O.C.V. et al. V. Bondi, published by the 10th Circuit on August 26, 2025. I'm telling you, the 10th Circuit doesn't do big asylum cases often, but when it does, man, it goes big. This is a monster, particular social group and nexus decision. Mr. O.C.V. is a member of a family of non-citizens from Mexico, all of whom are petitioners in this case. He is the partner of the daughter of Miss MRMS, and there are many children involved too. They lived and worked on a 212-acre parcel of farmland in Chihuahua, Mexico. Trouble began in 2017, though, when one of the sons was kidnapped. He was executed days later. After the murder, the La Linea cartel began calling the family from the son's phone. The cartel knew about the family, demanded they leave town, and threatened everyone. The calls continued until 10 armed members of La Línea visited the home and demanded that everyone leave under threat of death. The family went to Juarez and was followed by the cartel on the way out of town. And the threats didn't stop. The family thinks that the cartel was trying to prevent them from ever reclaiming the land. Evidence shows they did similar things to other landowners near their land, that is, the family's land. The family applied for asylum in the United States in 2017. Many asylum applications were filed by the surviving adults, but all were based on family membership, in addition to some land ownership based particular social groups. An immigration judge believed none of the groups cognizable, and in any event an insufficient nexus to what had happened. Just a cartel wanting some land, reasoned the IJ. The BIA affirmed in a published decision, explains the 10th Circuit. And I'm not going to lie, the 10th Circuit says it's a published decision, but I have no idea what decision they're talking about. But that decision is zombie precedent now anyway, right? Because the 10th Circuit reversed and remanded. In a big way. Like, a really big way. As we've talked to death on the podcast, the BIA's nexus rule is that a particular social group, even if cognizable, won't be considered the on account of reason if the group, like family membership, is incidental or subordinate to another ultimate goal. Like here, stealing land. Fair enough. But for years now, the BIA has been trying to have a special rule for family membership cases, in my opinion at least. And in the petitioner's opinions, too. Because here the BIA's rule was that, quote, if a persecutor is targeting members of a certain family as a means of achieving some other ultimate goal unrelated to the protected ground, family membership is incidental or subordinate to that other ultimate goal and therefore not one central reason for the harm, end quote. A matter of MRMS, similar rule, I believe. No nuance at all for family-based mixed motive cases, it would seem. The 10th Circuit disagrees with that rule. And oh smack, duh! The matriarch of this family is Miss MRMS, even though that's not the name of this decision. This is matter of MRMS from episode 187/188. The 10th Circuit just didn't list Miss MRMS as the lead petitioner. It's MRMS that's zombie precedent. Wow. Let's reset. Yes, a particular social group isn't one central reason if the group, family membership or otherwise, is incidental, tangential, or superficial to the persecutor's motive. But that doesn't mean it's always the case in family cases just because persecutors want something else. Quote, the existence of an unprotected motive does not negate that protected ground-related motives may also exist, end quote. The BIA can't just ignore evidence because it's a family case on nexus. So the 10th Circuit majority really had no problem vacating matter of MRMS. It, quote, readily concludes the BIA's new rule on nexus misstates the law, end quote. Me too, 10th Circuit. Me too. Go check out episode 187 and 188, I'm just saying. The BIA flat out took away mixed motive cases for family-based groups. Thank you for recognizing that, 10th Circuit. Violates the I&A and 10th Circuit precedent, and quite frankly, every circuit's precedent and even BIA precedent explains the 10th Circuit, in part. In reaching the holding, the 10th Circuit turned to BIA hypotheticals, the BIA's own hypotheticals, and turned them on their head, and found persuasive the 6th Circuit's takedown of MRMS and Mazziargos wrote us from episode 230. By the way, the podcast case page is back up after a few days of being down if anyone was having trouble finding cases. To the 10th Circuit, Oil didn't have a good argument, and I bet won't have one going forward in other circuits, because, quote, the government attempts to defend the BIA's nexus statement by rewriting what the BIA wrote, end quote. First, MRMS said what it said, explains the 10th Circuit. And also, as written by Oil here, MRMS would simply be saying what the BIA has been saying on nexus for years. So why make that precedential? Unless, of course, MRMS was trying to say exactly what the 10th Circuit is saying it did say and is wrong. And can we just again pause to acknowledge that Attorney General Garland appears to have been so hands-off with his BIA that he permitted MRMS's publication? I don't have proof, but I doubt Attorney General Garland ever knew about MRMS, and I strongly doubt he knew about it before or shortly after its publication. In stark contrast to the current Attorney General, who is literally telling the BIA what to publish almost every single week. It really just is something to behold, that contrast. Back to this case and why it held matter of MRMS is wrong. The 10th Circuit did reject the petitioner's other arguments that MRMS created a rule that impermissibly requires IJs to delve into the persecutor's mind. Motive is critical in the 10th Circuit, explains the court, relying on the Supreme Court, and a, quote, means ends framing, end quote, is permitted in the 10th. It does matter whether the particular social group is merely solely a means to accomplishing an unprotected end in the 10th Circuit. Probably a harsher rule than the one applied at a minimum in the 4th Circuit, though, explains the court, so don't forget that in the 4th Circuit. But of course, in such cases in the 10th Circuit, the non-citizen would likely only lose if family membership literally didn't matter or was incidental, tangential, or superficial. Nor is the BIA wrong to hold that the record must show animus towards the family, explains the court. But that just means that, quote, the dispositive question is whether the BIA erred in holding petitioners could establish animus for purposes of nexus by showing the persecutors harbored a desire to overcome a protected characteristic or some other form of animus, end quote. That animus can be considered doesn't simply hinge on showing that the persecutor desires to overcome the family membership, that they hate the family because they're a family. What does count? Well, under BIA precedent, quote, intent to overcome can thus encompass seeking to eliminate an undesired trait tied to the protected ground, end quote. Or under 9th Circuit precedent, explains the 10th Circuit, the persecutor need not, quote, harbor a subjective intent to punish, end quote. Seems like the 10th Circuit agrees with that. Heck, this can be shown, quote, even if they subjectively harbor no ill will toward the applicant, or even believe the persecution is in the applicant's best interest, end quote. Big deal, 10th Circuit. Relying on a very different matter of Kasinga BIA from very different times. By the way, again, even that apparently conflicts with an even more favorable ruling out of the 1st Circuit, I&N Dec Bondi, episode 262. Who could forget? Likely in the 6th Circuit too, explains the 10th Circuit in a footnote, this stuff is like an octopus. So, the court sent it all back for a correct nexus analysis. By the way, the 10th Circuit acknowledges but didn't decide here that withholding of removal might have a different lower nexus standard. Judge Timkovic would affirm the BIA but seems to recognize that the BIA committed legal error. And it all means mega congratulations to Ann Dutton of the Center for Gender and Refugee Studies, along with many others, including that great roundtable of former IJs on amicus, and warrior law firm Perkins Coie for repping them despite unconstitutional attacks from the alleged President of the United States. Also, Amica, formerly known as the CARE Coalition, is in on the action too. What a case. And I cannot stop, because actually it might even get more interesting. Back to the zombie precedent argument that I'm always talking about on this show. I have the issue on petition for review in the 11th Circuit, and am set to go to oral argument in December. Although who knows what will happen there, or if the court will even rule on that issue. But I firmly believe in it, that is, the zombie argument. And so I firmly believe that the BIA has no right to rely on matter of MRMS anywhere, nationwide, any longer, because the decision itself has been vacated on direct petition for review. Hit me up if you want to discuss when the IJ or BIA inevitably relies on matter of MRMS, nevertheless, to deny one of your cases. And oh mama, it's not just me. It seems like the 10th Circuit might agree, folks. First court that I've seen to maybe address the issue. In deciding whether to remand the matter, the 10th Circuit reasoned here, quote, we cannot leave uncorrected an agency's precedential misstatement of the law, because this unlawful standard governs a dispositive issue and appears in a published 3-judge BIA opinion, so it serves as precedent in all agency-level proceedings involving the same issue, end quote. Then, after that, it decided to reverse and remand. Why say that if the 10th Circuit doesn't believe that its vacatur now resolves the precedential effect of MRMS's misstatement of law nationwide? I am like on DEFCON 10 of mega nerd excitement with this, folks. Heck, in footnote 22, the 10th Circuit notes that it could have simply remanded without a full vacatur. So a vacatur with remand, as occurred here, must mean something, right? Oh my goodness. It's happening, zombie hunters. It's happening! And that is O.C.V. et al. v. Bondi. Let's see what's happening on the 5th Circuit. Sarabia v. Noem, published by the 5th Circuit on August 22nd, 2025. This is that decision that they published late last week that I didn't have time to get to. This is about certificates of citizenship. I'm going to just use the 8 U.S.C. citations because I'm too lazy to go back and put in the former I&A provisions, and in any event, you'll usually be litigating this case in federal court. So as I promised last week, here's the case published in the 5th Circuit very late Friday, 2 Fridays ago. Most of you do not know, because why would you, that the 5th Circuit publishes throughout the day, unlike almost all other circuits, and can do it as late as 8 p.m. Eastern Standard, which includes Fridays. Now, of course, on Pacific Standard Time, but 5 p.m. on a Friday? Even I try to have a life. So no, 5th Circuit, I will not simply live in your world and adjust my schedule to your unreasonable demands. It's time to take back my life. If from someone, then the 5th Circuit. Even if it's a long, non-citizen-friendly one. Or should I say, citizen? Mr. Villegas' mother is a Mexican citizen, but his father was born in Eagle Pass, Texas in 1955 and lived in the United States for the first 5 years of his life. I feel like Eagle Pass is often like at the center of these cases, no? Is it just me? The father moved to Mexico in 1960, 5 years old, but returned to the U.S. in 1965, quote, at which time he became a migrant farm worker, end quote. Now, I know I'm a lawyer, but doing that easy math, the father began farm work at 10 years old. And the father has lived in America ever since, as is his right. Mr. Villegas was born in Mexico in 1976. His parents were not married, but did the next year in Eagle Pass, Texas. The former citizenship law applies here because it's the law that applies at birth or at the time of the alleged triggering event. Here, that's 8 U.S.C. section 1401A7, which in 76 recognized the claimant's citizenship if the citizen father, quote, was physically present in the United States or its outlying possessions, for a period or periods totaling not less than 10 years, at least 5 of which were after attaining the age of 14 years, end quote. So he filed an N-600 with USCIS for a certificate of citizenship. USCIS denied, despite quite a lot of evidence about the father's history, although admittingly much in affidavit form. Also, quote, USCIS did not interview Mr. Villegas' father, who was in prison at the time, end quote. If, as here, USCIS denies, it goes to the AAO. The AAO dismissed the appeal in February 2018, almost 3 years after Mr. Villegas filed. He then filed a motion to reconsider and reopen, arguing in part that now the father was available for interview and included a more detailed affidavit. The AAO denied that quite quickly, considering September 2018. Just shy of 5 years after that, Mr. Villegas filed suit in federal court. So yes, he waited a long time to file suit. Most people don't usually do that. The district court ultimately dismissed the lawsuit, believing it lacked jurisdiction because the suit was untimely. It would have Mr. Villegas start all over again with a new USCIS filing. There is a 5-year clock to sue for a citizenship denial. The court believed that it was the AAO's original February 2018 denial that started the 5-year clock, rather than the September 2018 denial of the motion to reconsider. That's the district court. And that's not a crazy holding, but the 5th Circuit reversed and remanded. Because nothing is jurisdictional anymore after Santos Zakaria, Riley, and quite a few other non-immigration Supreme Court decisions in recent years, explains the 5th Circuit. Paraphrasing, of course. Many things are jurisdictional. Don't sue me. But a lot of the I&A isn't anymore. Congress has to be quite clear now if it's going to make an immigration statute, or any statute for that matter, a jurisdiction-stripping one. Quoting Santos Zakaria, which itself vacated a 5th Circuit decision, by the way, quote, where multiple plausible interpretations exist, only one of which is jurisdictional, it is difficult to make the case that the jurisdictional reading is clear, end quote. The court essentially overrules a prior, brief dicta-esque 5th Circuit discussion because of this new Supreme Court precedent. And the panel held that Section 1503A's 5-year deadline to sue is such a rule, a claims processing rule, not jurisdictional. And going back to that dicta-esque decision from the Fifth Circuit, quote, drive-by jurisdictional rulings contain no discussion of whether the provision was technically jurisdictional or what in the case would have turned on that characterization, end quote. Interesting. Here, non-jurisdictional. The statute certainly doesn't say that the 5-year deadline to sue is jurisdictional, explains the court. And in fact, the statute uses the word jurisdiction, but only to say which federal courts an action is to be brought in. Further evidence that the time deadline isn't jurisdictional because Congress knows how to use the word in the very statute it's discussing and uses it for something else. Nerdy, right? So as a non-jurisdictional claims processing rule, more is needed to see if Mr. Villegas' suit was timely. Although no mention by the Fifth Circuit of whether the government even invoked this claims processing rule, which of course it wouldn't have done, believing the rule jurisdictional and even winning on that issue below at the district court level. Reviewing the regulations, the Fifth Circuit does indeed believe that the February 2018 AAO denial can start the 5-year clock. Heck, the regulations contemplate situations where a motion to reconsider or reopen will travel alongside a federal lawsuit. That's why you've got to include that statement in your I-290Bs, right? But explains the court, quote, a motion to reconsider or reopen extends the time to file a Section 1503A proceeding when timely filed, end quote. Even though litigants need not file such a motion with the AAO. It's got to be a timely 290B, though, explains the Fifth Circuit. That is, filed within 30 days of the AAO's decision. Else litigants could potentially extend the 5-year litigation clock indefinitely. But if the AAO takes years to decide your motion, doesn't matter. You have 5 years from the denial. According to how I read this Fifth Circuit decision, so please do read it yourself and don't sue me. To do otherwise, explains the Fifth Circuit, would create chaos, forcing litigants to sue in federal court before agency proceedings were complete. It notes in quite the long footnote that the Supreme Court literally just blessed exactly that in Riley with the withholding only stuff, but the Fifth Circuit explains that the Supreme Court believed itself bound to create this absurdity by the statutory text, which is not present in the instant dispute. That is certainly one interpretation of the intent behind the Riley majority, and let's just go with that for purposes of this decision. So Mr. Villegas' district court lawsuit was just barely timely, sneaking in 1 month before the 5 years post-motion to reconsider denial. Wild. Meaning I guess there actually is no claims processing rule violation? For another case. Mr. Villegas gets his day in court. Heck, maybe his father's going to testify. Who knows? Godspeed. And here's some dicta. I mention dicta more often than some of you care to hear. Such are precedential federal court decisions. Many have asked precisely what dicta means. My mother, more than anyone. It means the portion of a prior precedential decision that the current panel doesn't like, of course. I kid. Here's a definition, quote, a statement is dictum if it could have been deleted without seriously impairing the analytical foundations of the holding and being peripheral, may not have received the full and careful consideration of the court that uttered it. A statement is not dictum if it is necessary to the result or constitutes an explication of the governing rules of law, end quote. So there you go. And that is Sarabia v. Noem. Hello, BIA. Matter of JAFS published by the BIA for this week's BIA decision. This case is about continuances. The attorney in this case received a couple of continuances for case preparation and other things. The attorney filed another motion for continuance on May 21st, 2025, with a June 5th, 2025 individual hearing scheduled. The IJ converted the merits hearing to a status conference, where Mr. JAFS's attorney, quote, stated that the respondent had been physically abused recently by his wife and requested additional time to ascertain the facts, gather evidence, and pursue appropriate relief, end quote. The respondent's counsel also explained that, quote, he was considering filing a motion to withdraw because of a past lack of communication and cooperation by the respondent, end quote. DHS opposed this motion as it had the one just before it. The IJ granted the motion, And this is what the BIA had issue with. IJs may grant a continuance for good cause shown. Attorney General Sessions listed some factors in matter of LABR and then used like 3 or 4 absolutely absurd and easily distinguishable examples of the types of cases where continuances would not be warranted. And from matter of Hashmi, quote, it is also relevant to consider whether the respondent merits a favorable exercise of discretion, end quote. And also, IJs should recognize the important public interest in finality, explains the BIA. And individual hearings are hard to schedule, explains the BIA. And, quote, immigration judges should closely scrutinize any request for a continuance that is made close to or on the day of an individual hearing, end quote. Don't want non-citizens to use it as a, quote, dilatory tactic, end quote. Quote, individual hearings that are continued close to or on the date they are scheduled often cannot be replaced with other cases and may result in wasting valuable resources, including the time of judges, opposing counsel, and hearing witnesses, the cost of interpreters, and the burden on other court personnel to reschedule the hearing, end quote. And I do imagine that those concerns must be addressed by an IJ and should be considered, whether or not the individual hearing is canceled last minute on a respondent's request, or because it's ICE not showing up with the file the day of, or it's because the IJ is being told by the administration to prioritize another case. Here, in laying down a rule, quote, while a continuance to investigate and gather evidence regarding a respondent's eligibility for relief is often appropriate at the start of removal proceedings, an IJ generally should not continue an individual hearing based on a respondent's speculative assertion that he or she may be eligible for a form of new relief from removal not previously raised, end quote. Plus, agreed the BIA with DHS, the new relief forming the basis here is quite speculative. And I see you citing Fonseca v. Garland, BIA, quote, clarifying the standard for prima facie eligibility, end quote. Is that your way of recognizing that matter of log rather than matter of Coelho governs the prima facie eligibility standard via cryptic parenthetical? I choose to read it that way, and you cannot convince me otherwise. I know it's for motions to reopen and that this is not a motion to reopen case, but I am still choosing to view it like this. In this case, the non-citizen didn't file an application for VAWA cancellation or evidence or anything like that, explains the BIA. Nor did the respondent present good moral character evidence. And both non-citizens and their counsel must be diligent, explains the BIA. Quote, respondents and counsel need to evaluate avenues for relief promptly after proceedings are initiated, rather than waiting until close to or at the time of the individual hearing, end quote. Proceedings here have been going on for like a decade, explains the BIA, a factor that might be relevantly distinguishable from other cases. By the way, this is ICE's interlocutory appeal of the continuance grant, which the BIA almost never grants, but will grant, quote, to address important jurisdictional questions regarding the administration of immigration laws and to correct recurring problems in the handling of cases by IJs, end quote. So go for broke, non-citizens bar, if your case presents such an issue, mid-case, and maybe get an interlocutory ruling. So, the BIA vacated the June 5th continuance grant and remanded the case in what is effectively an even larger continuous grant. But the BIA has made a point. And that is a matter of JAFS. Let's do 2 from the First Circuit and then take a break. Is that all right with you? All right. First, Lopez, Cano v. Bondi, published by the First Circuit on August 28, 2025. This case is about all the reliefs: cancellation, withholding of removal, and cat protection. Miss Lopez Cano is from Guatemala and received death threats from people jealous of her father's success at a meat shop. They frequently threatened to kill Miss Lopez Cano. She brought family-based asylum claims in immigration court. Or, I guess, family-based withholding claims. She's also been here since 2000 and has a U.S. citizen child with severe anxiety. Her other 2 children do not have health conditions. An immigration judge denied everything in a lengthy decision, and the BIA affirmed. Seems like she didn't even apply for asylum, actually, probably because of the 1-year bar. The First Circuit affirmed denial of the reliefs. First, cancellation. Deferential review post-Wilkinson, and all hardships must be weighed in the aggregate. That's a matter of Monreal itself. The First Circuit sees the challenge here as how the IJ and the BIA weighed hardships, but the court does not see reversible error. Not only does the First Circuit not see a fully developed record about whether the child with anxiety would even be leaving the United States, but it is unsure whether therapies can still be obtained in Guatemala. And in any event, it does not see this hardship, quote, substantially beyond the ordinary, end quote, as cancellation requires. That the IJ and the BIA didn't list and analyze every factor listed in matter of Monreal isn't reversible error, as those were just example factors, and maybe some aren't even present anyway. And maybe the IJ erred in not considering how Miss Lopez Cano's job prospects in Guatemala would cause hardship to her children. Maybe. But she apparently, quote, did not explain how her poor economic prospects in Guatemala would bolster her hardship claim, end quote. So on to withholding of removal. Even assuming the family group cognizable, the First Circuit doesn't see a sufficient nexus to the threats Miss Lopez Cano testified she received and fears. Her own testimony, explains the court, shows that they were targeted because of jealousy against the father's meat business success, and that other business owners in the area were similarly targeted. Turning then to Catwell, the court believes Ms. Lopez Cano waived the challenge, so it denied the petition for review. And that is Lopez Cano v. Bondi. Next is Ortiz Trejo v. Bondi, published by the First Circuit on August 29, 2025. This case is also about exceptional and extremely unusual hardship. Mr. Ortiz Trejo has lived in the United States without interruption since 2005 and has U.S. citizen children. He appears to be a good dude and supports almost all of the financial needs of his son and son's mother, but the son's mother also works. Doesn't make that much money, though. The son was 8 years old at the time of removal proceedings. The son appears to have pretty severe allergies and gets medical treatment for them. Other than that, though, normal 8-year-old who needs his dad. A psychological report was also submitted documenting how bad it would be if the son, who the BIA assumed would remain in the U.S., was separated from his dad. The IJ and the BIA found insufficient hardship, and the First Circuit affirmed that. Bringing legal challenges is always a good bet at the circuit level, or any appeals court, really. And so the first challenge here was that the BIA ignored the psychological evaluation, which you absolutely can't do under First Circuit precedent. The court just doesn't think that's what happened here. It reads the BIA's decision as being quite aware of the psychological diagnosis and, unlike in other First Circuit decisions, doesn't believe that the psych report requires a contrary holding, thereby supporting the BIA's decision and supporting a belief that the BIA did in fact consider it. Indeed, apparently the son's psychological issues weren't even really discussed by Mr. Ortiz Trejo or his counsel below. Now, Mr. Ortiz Trejo also argued that the BIA erred in relying on the IJ's boilerplate statement that he, the IJ, quote, evaluated all evidence of record, end quote. And true, we agree with Mr. Ortiz Trejo that an evaluated all evidence statement by the IJ cannot insulate the BIA's decision from legal error, end quote. That's a good quote. It's a good quote. But the First Circuit sees the BIA as having sufficiently done its job to review the IJ. And furthermore, that the IJ did in fact evaluate all evidence. Nor did the BIA misapply the exceptional and extremely unusual hardship standard. In reviewing the evidence about the allergies, the mental health issues, the mother working, and more, the First Circuit did not see grounds to overturn the agency, particularly considering its deferential review. So it affirmed removal of Mr. Ortiz Trejo from America. And that is Ortiz Trejo v. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2%. Plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. All right, so we're going to eat our vegetables with the Third Circuit before we get to 2 bangers out of the 9. First, Abdullah v. Attorney General of the United States, published by the Third Circuit on August 27th, 2025. And no shade, Third Circuit. It's an important decision. They all are. This case is about derivative citizenship. Went all the way up to the Supreme Court at one point, although the court didn't issue a substantive decision. Mr. Abdullah has lost quite a lot, it seems. He has lost again. He was born in Yemen in 1976 to Yemeni parents, but his father naturalized when he, Mr. Abdullah, was 9 years old. He, Mr. Abdullah, joined his father in the U.S. in 1990, so at 13, and has been a lawful permanent resident ever since. Or was he? Yeah. He claims his father filed an N-600 for him and his brother at the time. What the Third Circuit calls an application to naturalize, but which actually is a certificate of citizenship. So I'm not sure how helpful that would be anyway. That's pretty confusing. But the brother did somehow get a certificate of citizenship in 1995, explains the court. Mr. Abdullah claims he never received his, and his application is not in the record. For its part, DHS claims that an N-400 was submitted for Mr. Abdullah in July 1996, but was denied in January 2009. And you think your case is delayed bad, huh? In 2014, Mr. Abdullah was convicted of crimes that eventually made him removable, or so that's what the holdings were, and after going all the way up to the Supreme Court, he was conclusively deemed removable, albeit on some technicalities, it seems. Provided, of course, he's not a citizen, which he's not, explains the Third Circuit. First, though, actually, the Third Circuit does address the removal proceedings, not just citizenship. So let's do it. Mr. Abdullah filed a late appeal to the BIA. The BIA refused to self-certify the matter to itself. Third Circuit held that it lacks jurisdiction to review that because whether the BIA chooses to self-certify an appeal that's late is completely discretionary. No standard for the court to even judge whether the BIA's decision to do it or not was correct. Even so, explains the court, maybe it could review the matter if the BIA had, quote, a settled course of adjudication, end quote, for such things, and had diverged in this case. But the court doesn't see such a settled course. The BIA is just all over the place with self-certifications of late-filed appeals, legally speaking, and that insulates it from review. The Third Circuit believes its ruling here aligns with that of a lot of other circuits. Next, the Third Circuit deemed Mr. Abdullah's aggravated felony argument unexhausted because, right, he failed to make them before the BIA because, right, his appeal was untimely and wasn't self-certified by the BIA. Rough. Nor did the IJ lack jurisdiction over the removal proceedings based on a deficient NTA, for as we all know, such deficiencies are not jurisdictional. Explains the court. So, on to citizenship. As relevant here, the old derivative citizenship law in effect at the time held that children, like Mr. Abdullah, became citizens upon the naturalization of a parent, having legal custody of the child when there has been a legal separation of the parents. To me, Mr. Abdullah's got a few problems here. But here, the one focused on by the court is that his parents didn't separate until after his father's naturalization. The Third Circuit believed this fatal the first time around, but the Solicitor General and I guess the Supreme Court wanted the Third Circuit to review two precedential BIA decisions that, quote, the sequence in which the naturalization and separation happen is inconsequential, so long as both of the conditions are fulfilled, end quote. Presumably when the child is, well, still a child, I imagine. That's matter of Barris Lorius from 2008 and matter of Douglas from 2013. Seems like under those decisions, Mr. Abdullah might be a citizen. The Third Circuit, though, sees the Solicitor General as relying heavily on Chevron deference in her arguments for remand, and the Supreme Court did too, believes the Third Circuit. But deference, of course, is no more after Loper Bright. So the Third Circuit believes it doesn't really care so much about those BIA decisions, given that it believes its prior interpretation of the statute, a good reading of the statute, that in any event is foreclosed by prior Third Circuit precedent. That is, for people like Mr. Abdullah, the separation must occur before the parent naturalizes, not after. And that is the separation of parents. Much of this analysis actually comes down to the definition of the term when, which I know is super thrilling. I must confess that I sympathize with Mr. Abdullah on a mega nerd level. Seems that even the Third Circuit agrees that one panel said something in dicta that another panel then believed was binding, and so now this panel believes Mr. Abdullah's argument is foreclosed by that second decision, while recognizing that the initial dicta should never have been binding in the first place. Such is the deference accorded to prior panels. And really because of that, because of this panel's strict adherence to Third Circuit internal rules about the bindingness of prior precedent, the court did not really even entertain Mr. Abdullah's statutory interpretation arguments that the BIA has already adopted and that might just have made him a U.S. citizen had he lived somewhere other than New Jersey, Pennsylvania, or Delaware. How about that? And that is Abdullah, the Attorney General of the United States. I promised to bring the heat with the knife, and I'm bringing the heat with the knife. First, Ibarra-Perez v. United States, published by the Ninth Circuit on August 27, 2025. This is an appeal from a district court decision involving the Federal Tort Claims Act. You guys know I don't usually do these. Don't have time. And they're rare anyway. But this is special. First, the litigators are some of the best in the immigration biz, and some are friends of the pod. But two, if you listen to my interview with Ira, you'd recall that he believes the FTCA will be vital in holding this administration accountable for the next however many years we need to deal with them. Plus, it's just a dang interesting case. Judge Nelson dissented. And ultimately, the case is about jurisdiction. But sometimes, jurisdiction is everything. The U.S. government illegally removed Mr. Ibarra-Perez to Mexico. That's the claim, at least. He's from Cuba and received withholding of removal in the United States. Quote, before arriving at the United States, Mr. Ibarra-Perez spent several months in Mexico. While in Mexico, he was extorted by Mexican police officers and other authorities on multiple occasions and forced to pay officers money in order to avoid detention and deportation to Cuba, end quote. Mr. Ibarra-Perez applied for asylum in Mexico. Mexico denied asylum, but granted a 1-year humanitarian visitor permit, end quote. In his asylum application in the United States, done pro se but with the assistance of another immigration prisoner, he stated that he didn't believe Mexico safe. The IJ granted Mr. Ibarra-Perez withholding of removal from Cuba and did not designate Mexico or any other country as a possible country of removal. The IJ said she would have granted asylum but for the transit ban then in effect. Quote, that ban required migrants who passed overland through another country or countries on their way to the southern border of the United States to first seek asylum in one of those countries, end quote. Not only that, explains the Ninth Circuit in a footnote, the IJ likely erred in applying the transit ban, given that Mr. Ibarra-Perez again appears to have actually applied for asylum in Mexico, which would then apparently accept the ban. Wild. Mr. Ibarra-Perez, pro se, believed he was safe and so did not appeal the denial of asylum based on what might have been a clear error of law. But that's not necessarily correct. A grant of withholding or cat protection has always technically permitted removal somewhere else, and here ICE actually tried to do it. In January 2020, no less. This is not a recent case. They contacted multiple countries, and Mexico agreed to accept Mr. Ibarra-Perez. When ICE told him this in English, which he didn't fully understand, he understood enough to say he could not go back to Mexico. The ICE officer promised to return with more information, but never did. When things got more serious, Mr. Ibarra-Perez flat out told the officer that he was afraid to be deported to Mexico. Things got serious. Mr. Ibarra-Perez panicked, kept saying he was afraid. ICE handcuffed him and sent him to Mexico. Quote, at 9 a.m., Mr. Ibarra-Perez was released from Mexican custody. It was cold and rainy, and he was dressed only in the light clothing he had worn when he came to the United States border seeking entry. Mr. Ibarra-Perez went to a Mexican government office at about 11 a.m. A woman at the office told him to go look for work. At about noon, Mr. Ibarra-Perez contacted his daughter in Florida, who wired approximately $100 to a bank in Mexico. He slept that night in a church-affiliated shelter. End quote. When he went to go look for work the next day, 3 men stopped him at gunpoint, showed him a photo of himself getting the money his daughter sent him, and told him that he could either pay them $500 a month or he could be a drug mule for them. Other immigrants at a food hall told him that they'd heard of this and that people like him had ended up dead. Quote, an attorney from the Florence Immigration and Refugee Rights Project was providing legal services to the Cano border initiative that day. The attorney contacted an ICE official. Later that day, accompanied by the attorney, Mr. Ibarra-Perez presented himself at a port of entry in Nogales. Mr. Ibarra-Perez was allowed to physically re-enter the United States, but was taken into custody. End quote. Incredible. He was placed in proceedings which were eventually transformed into reopened proceedings before that same immigration judge. Then during all that, the Ninth Circuit held that the transit ban was invalid, so the IJ granted Mr. Ibarra-Perez asylum based on the Cuba stuff, deeming withholding of removal and cat from Cuba or Mexico moot. ICE did not appeal. How is this not the end of this already fascinating story, then? He's got asylum. I see. Quote, Mr. Ibarra-Perez brought suit under the FTCA for damages suffered as a result of what he contends was an illegal removal to Mexico. He alleges false imprisonment, negligence, abuse of process, and intentional infliction of emotional distress. End quote. Apologies. I thought, or I guess assumed, ICE was going to deport him again in this story. The district court dismissed that lawsuit for lack of jurisdiction, but the Ninth Circuit majority disagrees. All right, that's the end of the interesting stuff. We're in boring jurisdiction land now. Because the Ninth Circuit didn't get into whether it thought the claim had merit, that is, whether the initial removal to Mexico without a reasonable fear hearing, and where an IJ never designated Mexico as a country of removal, was illegal. I won't get too into the weeds, at least I'll try. Suffice it to say, you must read this decision if you're bringing an immigration FTCA action. This case is about INA Section 242G. That statute provides in relevant part, quote, no court shall have jurisdiction to hear any cause or claim by or on behalf of any non-citizen, arising from the decision or action by the Attorney General to commence proceedings, adjudicate cases, or execute removal orders against any non-citizen under this chapter, end quote. So it's about the last phrase, right? DHS is arguing that this is simply about executing a removal order, albeit to Mexico, and so district courts lack jurisdiction. Supreme Court, however, explains the majority, has given this statute a narrow reading. Courts can still address certain legal questions, quote, even if the answer to that question forms the backdrop against which the Attorney General later will exercise discretionary authority, end quote. Citing, among other things, to the First Circuit's Kong decision, another monster FTCA case, episode 151. Sufficient legal claim here to get around 242G, explains the court. Quote, he does not contend that ICE was categorically forbidden to remove him to Mexico. Rather, he contends that he had a right to a meaningful notice and an opportunity to present a fear-based claim before he was removed to Mexico. End quote. That's how you do it. A contrary reading would flat out potentially let ICE do illegal stuff with no judicial review, explains the majority. Nor do I&A sections 242A5 or B9 bar the claims, arguments that the government didn't even make, but which the dissent does go through at length. That is, that only the petition for review process permits a suit, or I suppose a challenge such as this, which of course would be impossible. Explaining and distinguishing lots of its prior precedent and arguing with the dissent, whose opinion is longer than the majority's, the Ninth Circuit sent it back to see if Mr. Ibarra-Perez is owed that cash money. So, congratulations, Trina Realmuto, Mary A. Kenny, and Aidan Langston from the National Immigration Litigation Alliance, or NILA. Congratulations also Laura Bellios and Rocios C. Acosta from the Florence Immigrant and Refugee Rights Project. And congratulations Matt Adams and Christopher Strawn from the Northwest Immigrant Rights Project. For amicus curiae, Northwest Immigrant Rights Project. Monsters. And that is Ibarra-Perez, the United States. So let's conclude with Lopez v. Bondi, published by the Ninth Circuit on August 25th, 2025. This case isn't really a decision per se. It's a denial of panel rehearing and en banc rehearing. This is that big important CIMT decision that we did on episode 229, litigated by really smart lawyers. Go back and listen to that episode. The decision decided a lot of things. But perhaps most importantly, it was one of the first, if not the first, deep dives into what the circuits would and should do post-Loper-Bright with ambiguous I&A provisions, which for so long the circuits had subjected to Chevron deference. Just kind of listening to what the BIA said. Like, for example, the CIMT definition, or what it means for crimes involving moral turpitude to be in a single scheme of criminal conduct. The circuits to have addressed the issue post-Loper-Bright have thus far uniformly agreed that their old decisions are subject to stare decisis and therefore bind, even if those old decisions relied on Chevron deference, although chips in the armor have developed a bit. That whole shebang appears to have been argued on rehearing. Seems like the panel made short shrift of it, although Judge Sanchez votes for panel rehearing for reasons that might not relate to Loper-Bright. Unsure, but I do seem to recall his dissent or maybe concurrence from the initial decision. But the full Ninth Circuit also wanted in. Now, en banc rehearing did not succeed, but Judge Bumate, Akuta, and to an extent Collins, dissented from en banc rehearing. I suspect more judges on the Ninth Circuit might agree with them, but en banc rehearing in the Ninth Circuit, unlike all other circuits I believe, doesn't actually mean the full court. So I don't know how many Ninth Circuit judges even got a say here, and so I don't know how many agree with Judge Bumate. Judge Bumate for the dissenters had a lot to say, and who knows, maybe the Ninth Circuit will go en banc on the issue eventually. If nothing else, some of what he has to say should be reviewed and argued in other circuits, where the stare decisis issue post-Loper-Bright has not really been fleshed out yet. Taking a step back, the Lopez panel believed that a prior decision about what it means to be a single scheme of criminal conduct for CIMT removal purposes was still binding, even though that prior Ninth Circuit decision had relied on Chevron deference. There was Zonyi v. Whitaker. Not so, though, explains Judge Bumate in dissent, quote, as Loper-Bright was an intervening higher authority that is clearly irreconcilable with Zonyi, the panel was well within its right and in fact duty-bound to revisit Zonyi, end quote. Which is exactly what I keep saying at all these conferences and on this very podcast. I'll take a dissent of rehearing en banc because it's the best I can get at present. Indeed, quote, this should have been a straightforward case of overruling bad circuit precedent, end quote. Indeed. Judge Bumate also goes on for many pages about how the panel was way too deferential to the BIA, given Loper-Bright. He also starts a whole section with the title, quote, A Brief History of Judicial Deference, end quote, that begins with Marbury versus Madison, and which you should steal from, I suppose, if you're making this argument elsewhere. Also in a footnote, Judge Bumate explains how the concept of a CIMT was present at the founding of the nation. But I don't know. I don't know there, Judge. I mean, even if so, I bet Mr. Jefferson and Hamilton had very different ideas about what moral turpitude was, and maybe even more importantly, to today, what it wasn't, right? Kind of supports the argument that the CIMT concept is ambiguous, unconstitutionally so, but that's just me. Judge Bumate explains himself in detail, and would have judges start by, quote, looking to the historical underpinnings of the early immigration laws and the original meaning of moral turpitude in the late 19th to early 20th centuries, end quote. I'm not going to lie, I do not want to live in that world. But, of course, that is a judicial interpretation. Back to Loper-Bright, though, because that's why I'm doing this dissent from rehearing en banc. All the courts who have addressed this issue are relying on that one sentence from Loper-Bright, quote, we do not call into question prior cases that relied on the Chevron framework, end quote. But to Judge Bumate and the other dissenters, they're agreeing with what I've been screaming into the void. Quote, in context, it's clear that the court was expressly discussing its precedent, end quote. Emphasis from Judge Bumate. The Supreme Court was talking about how its prior precedent was still owed stare decisis, not that the lower circuit's prior precedent was owed stare decisis by the circuits. I will die on this hill with you, Judge, should you like. Quote, that statement in Loper-Bright makes sense given the distinction between vertical and horizontal stare decisis. Overturning Supreme Court precedent requires different considerations than overturning lower court precedent. As judges on this court have previously recognized, the Supreme Court's obligation to follow stare decisis differs from that of circuit courts, end quote. Agreed. Much easier at the circuit level. The Supreme Court simply needs to issue something that undercuts prior circuit precedent, and that prior circuit precedent is then free to be disregarded by the next panel that comes around. Other reasons for this too, explains the judge. Of course, it's a dissent from the denial of rehearing en banc. So if nothing else, copy and paste this into other circuits, folks. Well reasoned. And that is Lopez v. Bondi, the dissent from the denial of en banc rehearing. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.